at the bottom. Georgia courts have developed their own standard for disqualification of prosecutors.
Say, I don't recall. I don't recall. Pull up Terrence Bradley. Oh, that case? I don't recall.
Oh, shit. Wrong channel, but oh well.
I'm so sorry. I'm so sorry.
Microphone just put
course.
closer to you.
Yes, I want to make sure I'm following the same one. You're talking about defendant supplemental reply that was filed on February 9th at 3:47?
No, let's go back.
Okay.
Let's use your first one.
Okay.
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 Yeah. I want this a little bit more. Okay. So that one there.
Yeah, I realize that. It's too late now. Might as well just keep it going. I already blew the notification.
24.
Page 24.
Just a quick drive.
Okay, so this guy's like grasping, right? He's trying to grab some low-hanging fruits and stuff.
The site
He can.
is Whitworth. The court recognized a conflict of interest as a ground for disqualification. Held to arise where the prosecutor had acquired a personal interest or stake in the defendant's conviction. And I don't, you know, I wish I had that case in front of me. I don't have the case in front of me.
Yeah, thanks for asking her about
essentially, to answer your question, that first of all is
Late start? Yeah, a little bit.
So, yes, and we
But you did cite it.
and said that it's physical precedent only.
And you're using the basis really to say it's a conflict. There's no other case law that you actually use in this particular brief to say it's a conflict. That's
It's a matter of first impression in Georgia.
Sales, which deals with contingency. And so in Whitworth, I mean, I have a case, I want to go through it. It actually talks about that there's
More
citing the conflict.
More interviews.
The judge would do that.
If he had, or the prosecutor had actually spoken to the defendant. Has that taken place? Okay. Second, has he represented the defendant?
Pressing them.
There was a motion early on. It was, I didn't even bring this up here, and I don't think we talked about it in the brief, but there was a motion early on because Mr. Campbell, who's Mr. Wood's law partner, actually sent a mailer out to my client and all of the other defendants. Yeah. So I don't think anybody called based on that, but they did advertise to them saying, call us to represent you.
Yeah.
And then they came with the third, which says it has a personal stake in the defendant's conviction.
Right.
So is that what you're relying on there, that there's a personal stake in his conviction?
No, in the prosecution also. So, and in that case, that's physical precedent only, and I don't remember the specific facts of that case, but it's not just a conviction. And obviously, the state wants it to be just a conviction, and we argued this extensively over 3 hours, I think, in front of the court, but it's also a personal stake in the prosecution, and that was an amusement. You know, prosecution in that case, that was a contingency fee case. So
That's
that was
correct.
completely different. Yeah.
And so in amusement, it was a contingency fee case. So they had a personal stake actually really in the conviction because they only received the contingency fee when the conviction happened.
Right.
So what you're really saying is that they had a personal stake in just bringing the case because it can't have, there's no personal stake in the convictions similar to amusement, correct?
So amusement's a little bit different because there is no conviction in a forfeiture.
Correct, but they're going to get money if they win.
Right, but there's no conviction.
But they're going to get money if they win. That's the
They
case.
get money if they keep the forfeiture. So it's where, that was a forfeiture case. I think that was like game slots.
That's correct.
Yes.
But they get money if they win.
Right.
That's not how they get money.
Yes.
They don't get money for bringing it.
So I just wanted to make sure it was clear.
Right.
That was not conviction because you can't have a conviction.
But they only get money if they're the victim. He's receiving his funds. Mr. Wade is receiving his funds because he's billing because the case is going on, correct?
If he dismissed it, he would not be able to bill anymore.
The case.
No, he can lose the case and still have
Absolutely.
Make a ton of money off of it.
So what you're saying is the actual conflict is just bringing it.
No, the actual conflict is, that's a long answer. The actual conflict is lying on your disclosures about how much money.
I'm talking as far as this issue is concerned right here. We use the Whitworth, you use amusement sales, and they say that there has to be an actual conflict. And amusement sales, and let's go back to Whitworth if we can, because in Whitworth, the person was actually told, the prosecutor was actually told by another prosecutor.
This is so petty, it's
that they want the case to actually resolve in a conviction. Because what happened was, the defense attorney came to the prosecutor and said, we would like to plead. The prosecutor basically said no. He went and got advice from somebody, and that prosecutor up in a conviction. And so the question, and that then was held not to be a conflict. But that still is not an actual conflict, even though someone told that prosecutor. We want to see a conviction. We actually want to see it go to the end. Don't plea him out. And the court said, no, that's not an actual conflict, because what you have to show is there's an actual unfairness to the defendant in the trial. Can you point to any unfairness in the trial that's taking place?
It's not the trial, so it's not limited just to the trial. But to answer the first part of your question, when you were asking about the conviction of personal mistake, Ms. Willis has made numerous public statements about her interest in a conviction. There's emails that had been admitted as part of it, as part of some of the exhibits in the case. There's a lot of pleadings, so I don't know which one exactly, but talking about her desire for there to be a conviction and jail time. And then in my case, for example, so Mr. Wade offered my client misdemeanor probation. So we were the first people to get an offer. And we said no, we wanted a dismissal because he was not guilty. And that did not happen. So obviously there's an interest in him being convicted of something, because when the plea offer was for him to pay a $5,000 fine and have a misdemeanor.
So in reality, because you said that he wanted to extend the case out, he was actually trying to end your client's case.
With a $5,000.
But it was going to end. It was with no more bidding on that case, because earlier you said that you believe, which was total speculation, that they created this case against your client to do more billing. And what you're just telling me now is that he was willing to stop his billing because he offered your client a misdemeanor and you rejected it. You continuing the billing.
I don't bill by the hour.
No, you're the one that's continuing to make him bill. He was willing to cut that off. You said,
so you should just plead
I believe
guilty.
that they created this case against my client.
Hey, freedom,
so they can continue.
freedom.
Well, he basically went out and said, I'm tired of billing. I mean, and you said no.
Take a couple notes.
You should
You
just
had a couple
plead guilty?
questions there. I want to make sure I answer all of them. So the billing, so as far as the billing and the offer. So what I was trying to explain, I'm glad you gave me this opportunity to sort of go into it in a little more detail. I tried to explain that there are really three classifications is how I broke the indictment down. There's the folks that are involved at the federal level. You see those people having, they were in D.C. Then you see the electors. Then you see coffee. These cases could have been handled.
We can't even hear you.
Oh, I'm so sorry.
Just pull
I
it
didn't.
up right
Sorry.
to you. Pull it to
We
the
can hear
definition.
that other dude breathing.
Okay. Sorry.
He's breathing in the
So
mic.
how I was trying to explain it is I separate this down into three different types of cases. And it could have been handled that way. Coffee County could have been prosecuted in Coffee County if it had been chosen to do that. The stuff with the federal could have been handled in federal court if they had chosen to do that. Then the electors would have been the only remaining case that could have been prosecuted in Fulton County. Instead of choosing to do that, it's not just my client in particular, but that group in the middle. By putting them all three together, it expands the litigation. How it expands it is a couple different ways. It expands it because when you charge a RICO case, you can bring in evidence of everything. So essentially, instead of having a case, a quick case, a case where there's evidence against Michael Roman, only Michael Roman, you litigate that. They expanded it to include these three different classifications. What does that do? That means the trial is going to be a year. They can plead people out. They can plead Michael Roman out. They can plead this person out. They can plead people out. But it's always going to have that large enterprise. And it actually does, even if they pled my client out, the offer was for him to testify. So, for him to testify, even though he would not be on trial, his acts would still allegedly be on trial, which still expands the litigation because he's not gone. The deal's not, you can plea out and you're gone. Bye. We're not taking up time with you.
Nicely
it still
done.
expands it. So it's still, so
that
my
make
point
sense,
earlier was that this
Senator?
expands the litigation. Because imagine if we just had, like you see in one defendant, you can limit the information to just that crime and that case, or you could have three separate indictments. But what we've done here is we've put them all together. You've made it so that it's necessary to try them to have three trials because there's no courtroom that can fit all of those people. So that expands the litigation.
And if
So
Nathan insisted,
in the case that you cited, what's it called?
oh gosh,
Whitworth. It says specifically that when the prosecutor goes up, Morgan, who is the person who's not supposed to, who's talking to him, who's the prosecutor, Hobbs informs Morgan, who's the prosecutor.
Morning, Lucky.
That he correct.
And again, I don't have Whitworth in front of me, and there's a lot of different facts about these cases. I would be happy to review it and let you know. But what I can tell you is that I still, and we still believe that this is to expand the litigation. And even if it's minor, the law says over $100, that's to have a personal interest. So what we've got is we've got these financial disclosures where they're not being truthful. Ms. Willis is lying under oath. which is the same thing my client is charged with conspiring to do.
Yeah.
Lying under oath about
Only one
receiving
gets
a
Hello.
benefit over $100. So you've got those. You've got this because of the last couple of months, this concerted effort to hide this information from the public, to keep this information out. I think that it is very reasonable for a court to think that that is a conflict of interest. And whether or not it's a stake in the conviction, a stake in the prosecution, we definitely have seen a stake in the prosecution. And you know, Whitworth, the problem with Whitworth, and this is...
Who actually brings the case?
The district attorney. Well,
How did I get the case?
more now because of the book Find Me the Votes. So we know a lot more than we normally would know. So, and that's one of the things that I talk about in my motion. In this case, it was actually Nathan Wade. So the one that he presented most of the witnesses, presented...
How was your client charged? How were these clients charged?
My client was charged just in the actual grand jury.
Okay, so a grand jury.
Yes.
Okay, so we had a special grand jury, and then you had a grand jury
Yes.
who made this determination.
Well, yes.
They made a determination to bring charges, basically, to indict, correct?
Yes, and I...
So are they part of all of this?
No. But I've never had the privilege of being inside of a grand jury, but I have heard a lot about what happens inside of a grand jury. It is a witness who comes, and in this case, it was actually the investigator for the DA's office. So just understand this: it is a very low standard of proof. It's probable cause. I have had clients who were dead indicted. I actually had a lawyer that I worked with at the public defender that was indicted along with his client because the DA presented an indictment that actually had the lawyer's name on it by accident.
Yeah,
And the
it's
grand
a
jury
joke.
indicted
So
him.
you're saying grand jury has
About
flaws?
that all the time. Yeah.
100%.
Oh.
Yes.
So would you think it'd be better for just the prosecutor to draw the accusations?
No.
So the grand jury...
I know you guys have a bill doing that right now. No, I definitely don't think so. The grand jury is better than no oversight.
Correct.
Definitely, but
Right.
it's a continuum. So my point in bringing that up is the grand jury is not perfect. The grand jury is... I'm not allowed to be part of the grand jury. It is not what I would call adversarial. So the grand jury is one-sided. They only hear from the prosecutor. So, and they hear hearsay. So in this case, using it as an example, the investigator for the DA's office listened to all the January 6th testimony, read all the testimony, went and summed it up for the grand jury. They present, the grand jury doesn't draw up the indictment. The prosecutor brings that indictment. And then they vote, and it's a majority. So all they have to do is a majority vote, and it's by a very low standard for probable cause. It's about 25% proof. So you've got hearsay, you've got a witness who hasn't actually witnessed anything personally, you've got a standard of 25%. I think there should be much more safeguards on the grand jury process personally, but that's for another day.
So with the special grand jury, and they made their recommendations. They went to a grand jury, and they, of course, made their recommendations. And how many persons have actually pled in this particular case?
2 or 3.
2 or 3
And
already.
they were lawyer. Well, there was one. So the first gentleman who pled, he was a bondsman, and he was not, because of the
Paul
state's law for
Cesaro
bonds,
Powell
bonding
Ellis.
agents, he's not able to act business while he's on bond. So he had a significant financial interest in entering a plea early on because he was essentially couldn't work if he
All
didn't
diversion
have
was
it.
too.
And I mean, he got probation. Now, it was not not what you would imagine in a huge racketeering case. You would not imagine probation and a $5,000 fine. The other 2 people who pled are with lawyers at the end of their career,
and Sydney. Sorry,
I can
Jenna
imagine
Ellis.
when I'm close to retirement and I have my retirement funds, if I would want to spend them on a criminal trial or spend them seeing my grandchildren, I would spend them seeing my grandchildren.
One of the things we've been talking
Jenna
about
Ellis
is
put on
Mr.
out.
Wade's kind of qualifications. So,
Yes.
but you did mention early on that he was very instrumental in the special grand jury process. So he's been there. He's been part of this process.
Oh, you can see that by his bills, yes.
Right. So other than just his bills, you said that you recognize that he's been part of the process. So even though he's very, I guess, what everyone's saying is inexperienced, he was able to go to a special grand jury and get the recommendations.
He's good.
He's able to go to a grand jury and get indictments, which is positive for the state side. And he's actually had some persons actually plead guilty. So this inexperienced former assistant solicitor, I mean, he's not doing too bad, is he?
That would be up for dispute. I mean, if you want to talk about his qualifications and whether I think he's qualified, I'm happy to talk about
No,
that.
I'm just saying. I mean,
Hey,
when you say
Midwest.
someone's totally unqualified. That's basically what's been going on. It's very surprising he was able to go to a special grand jury. You say he's integral to
That's
that.
not surprising.
And he's going to
It's not
the grand
surprising.
jury.
Yeah, you could put a 7-year-old in front of them.
Then why even say that he's inexperienced? And he's getting people to plead guilty. And basically he's saying those are
They're
just-
diversion deals.
They don't want to do anything.
They're all going to be dismissed if they're getting no convictions.
No. So the special purpose grand jury, first of all, remember my client was not recommended as far as that.
I understand.
The special purpose grand jury, I've had the opportunity to read a lot of the transcripts from that. It's direct examination. So you're bringing a witness in and you're talking and you're saying, tell me what happened. So he did that, and he never did it all by himself. He did led it, but Mr. Wooten asked a lot of questions, and there were some other prosecutors in and out, but he was always there. But that, I mean, special purpose grand jury is really just to investigate and get testimony.
I understand.
So it's not.
But when a person's trying to insinuate that someone's basically totally unqualified, it is important to realize that they brought this case to this particular very complicated case, I'd imagine.
This is also a minor issue.
That's something that we can debate. If walking someone through the grand jury, the special purpose grand jury is complicated or not.
Not complicated.
Asking questions, and again, there's a team of 10 lawyers.
So that's the team of 10 lawyers.
Who knows what part he's doing? But the question would be then, why him? Why not all of the public servants who are taking government salaries and restricted in their private law practice? Why do they need him there when there's all these other people? As far as the qualifications, asking questions of special purpose grand jury in and of itself, I mean, there's no opponent, there's no adversary, there's no judge.
Once it became adversarial, you've had persons start pleading. And maybe be more potentially correct.
The diversion.
But we'll find out.
Diversion.
But let me ask you this though, because you're talking about the staff. One of the reasons you may go outside counsel could be the fact
Oh, nice.
that this type of case within the office.
On the road again soon, huh?
To some extent. The office was basically shut down. So
Especially Terrence
DA's
Bradley.
office was basically shut down.
If you took the $1 million that he's been paid, you could hire 5 lawyers.
You could do that, but how long would you be able to keep them? In other words, if you had 5 new inexperienced ADAs, they're not tackling this case. And also,
Well, the inexperienced ADAs are not going to make
He's going to-
$1,000. So if you're hiring inexperienced ADAs, you'd probably be able to hire 20. But that's not what.
But the key thing
For
is
50 to 60
that
grand.
job that you're talking
Not
about, that you're going to
150.
hire with that, with the $1 million that you're going to pay him,
Yeah.
if that's your theory on it, that's not going to stay. That's not necessarily going to be long term if you're just doing it you're just saying the money you paid him, you could have done this. Because his is a short term kind of situation.
They
His
had
is no
appropriated
contract,
$5
it's
million to
short-term.
those new
It's not
DAs.
a
That was
long-term
COVID money.
contract. It's not going to last for a person's career. So
They
I
re-up
understand
it the
back
next
and forth
year.
from persons who are saying, well, they can use this money for that. But that money was delegated for him on the short term.
No, it was not.
Project, so to speak.
No, it was not.
So it's not anything that a person would come
It was
in
delegated for
and
COVID
actually necessarily
and the
do.
backlog.
But at the same time, that would be up to the district attorney to make that decision, how she's doing that. I just make the point that so far, from a district attorney standpoint, I would say that they probably believe that so far the case is successful. And we can argue about
They
what's
shouldn't.
qualified and what's not, but
How much
certainly
jail
I
time
think
did
that
they get?
would argue
Zero.
at this point the case has gone from a successful pattern for somebody that's been
Single
very
conviction.
qualified.
They're all going to be dismissed.
I do
Every one
wanna
of
go
those
to-
convictions is
How
going to
much
be
was
dismissed.
the money? Go ahead. Thank you.
Is that a question? Because I'd like to respond if it is.
Yes.
Please.
Okay. I took notes because there were a couple different questions in there. So
He's
the
just
first
ranting.
one, you said about how much money. So Ms. Willis had stated that it would be between $3 or $4 million to actually pay Mr. Wade completely to prosecute this case. So you'd be able to hire a number of prosecutors. Some of them do come and go, but most of the prosecutors we've seen on this case have been there since the beginning. So, unfortunately, these cases take time, so people may leave. You also asked me about that this money was delegated for this. And I just wanted to make sure that my testimony was accurate. This money was never delegated for this. The
Never.
county did not ever delegate this. The county was not involved in that at all. Ms.
Senator.
Willis is the one that decided. And there's no budget. There's no transparency at all on this.
She does the contract with him, and I believe you showed those contracts. So in that sense, it's delegated to him because that contract can end at any time. She could say, "Hey, the contract," because he works at her pleasure.
Oh, yes.
So that contract can actually end at any time. That
Yes.
Yeah, he definitely works at her pleasure. Right
how
about
many
that.
trips? How much total were the
gross.
trips?
About $20,000.
And I think about 17,059. But even if you say 20,000, what was the average cost of each one of those trips?
Oh, gosh.
Well,
Unfortunately,
They were
they did
low
not
cost?
provide all of the records, so I can't tell you exactly. All I can tell you is what Mr. Wayne charged on
He
his
got a good
credit
deal.
cards. I can't tell you. Most of it was paid in cash, so there's no record. So I wish I could tell you, but
Going by your slide, one was 3,335, one was 4,453.
Which one? Hold on, I want to make sure I'm clear.
Takes trips.
Okay, but which trip are you talking? You said one is 3,000 something. I want to make sure I'm clear.
Yeah, put it back up. There you go.
Okay.
So the first one, Royal Caribbean, 3,335, Aruba, 4,453. And then you see the next one, and then the next two.
Is he going to say that those are cheap? Those are good deals.
How does that compare? I mean, what is that
He is
so unusual for on price points of first trips?
I mean, I don't think so. The Royal Caribbean, so I can tell you because I know these records really well. I mean, Royal Caribbean, I specifically kept out the money that he spent on his mom's cabin. So they had two cabins. His mom had a cabin. They had an oceanfront balcony. You know, for Bahamas, I think oceanfront balcony is probably.
They got good deals on their cruises,
but I
so
don't know the
therefore,
numbers.
no problem.
Flew, comfort class, not unnormal for a lawyer.
Do you know what maybe the average American spends on vacation?
Not this much.
Not that much.
No.
Have you looked?
No, I haven't, but I would imagine most of the Fulton County taxpayers would love to go on any of these trips.
Well, you know, since you speculated, well, I could speculate and say that you did look, and that's why you didn't put it in your brief, because Forbes actually says that the average is about $3,700 that a person spends on
For a single person or a family?
family of four. But at that time, they were taking 2 and 3 at the time.
Are they
That
going
So
makes
that
sense.
makes
So these,
that's
no,
about
hold on. I want to make sure that's clear. You said they were taking 2 or 3 at a time. All of these, I made very certain that my numbers only included the 2 of them. So the one trip that they took
But
his
it's
mother on,
2 adults.
2 adults, yes.
It's nothing extraordinary.
So you said $3,700 for a family of 4.
What a
That does not
stupid
surprise me.
line of question.
For families that can't afford to go on vacations, doesn't.
Basically what the average American would do.
So that's
Yes.
this is half of that for 2 people. So you said $3,700 for a family of 4. This is for 2 people.
Right, it's just 2 people.
And do they go 4 times in a year?
That
Do they go
So
20,000 a year?
It's 2 adults. Bottom line is it's not extravagant. It's not lavish. It's
the law only says $100.
It's not lavish.
That's one of the reasons I
Sounds
didn't
pretty
include
lavish to me.
Ubers. I quite frankly didn't want to do the math. But there were a ton of Ubers on each of these trips. There was a hotel at the beginning of the Royal Bahamas.
Restaurants,
I didn't include that.
food,
I didn't want to do the math, and I
massages.
also did not.
How much shows?
250,000.
So
It's in my
your
brief.
argument is that a person who makes $200,000 a year is actually setting up prosecutions to go
Hey, John.
on a trip that costs $3,500.
Yes, she likes straight juice.
No, not in isolation. I mean, you're talking about in isolation.
No, I'm not talking about isolation. I'm talking about what's in briefs. I don't know what else you may be speculating about. I'm just talking about what's in briefs that says this is the benefit that she got. And all I'm saying is that I got a person who's making $200,000, and the benefit that you're putting into the briefs, not what you may say that you may find elsewhere, but the benefit in the briefs is I go on a trip for $3,300, $4,400, and they have made up all these prosecutions to go on a 3-day cruise for $3,300.
They went on
That's your
multiple
argument.
trips.
That's your argument. That's your argument.
That's not.
That's in the brief.
That's not our argument. So we did
What
argue
else is
for
in the
about
brief?
hours.
What else is in the brief?
What else is in the brief?
Yes.
A lot of facts, a lot of law.
No, as far as actual financial benefit.
So the financial benefit that I put in the brief was what I could prove. I did not want to have any, as you call it, speculation. I did not want to speculate about anything else. So I did not know if Mr. Wade paid for an Uber that Miss Willis was literally sitting in at the same time. You can kind of assume because it's from the airport to the hotel, but I did not.
They're
want to
both in
speculate
it.
to that. So I didn't include those in the numbers. So the hard numbers in here are all of these numbers that are
That's what's in the
shows.
brief.
Yes, the ones that I actually had hard numbers that I knew that she had. Yes, that's in the brief.
In our business, we deal with proof, and so that's the proof that we
Exactly.
have.
That's what I
that
did.
person
Yes.
is doing all of this for you.
Right. Oh yeah. And so what I included was what I had the actual hard proof of.
Hey, Lori.
Some of it's attached to the brief. Some of it I got by subpoena.
I accidentally started the stream with the wrong channel, but since I already started it, there was no point in stopping. So.
Those actually. And there were a lot of other receipts that I had that I did not know for sure if they were joined, and so I didn't include those. And I haven't
You
talked
should.
about it today.
Correct.
Exactly.
That's correct.
I 100% agree.
So this is what we're dealing with.
Yes, you're dealing with the stuff
Okay.
that's hard proof.
Correct. Okay. So my next question comes on the conflict as far as his salary is concerned. Just curious. Is it the amount of salary that really creates the conflict? I mean, because we get stuck on
Not
money.
really.
So it's the
Yeah, not
amount
really.
of salary that is creating this conflict in your mind.
No,
Or it's just the fact that he gets any salary at all.
No, it has nothing to do with that. I did not make any allegations against Mr. Floyd or Ms. Cross. It's the fact that they were sleeping together and he was paying for trips for them to go on, and they were hiding it from the taxpayers.
We just discussed that.
That's
So if there's not a trip, then you don't believe it's a
Oh, nice.
Oh,
Nice.
I do, because
I actually have a friend here that does
say that they
the mugs and stuff. She's really good at it with the epoxy.
If there's no hiding that against the
They were.
ordinances,
They were
do you
hiding it.
believe- do you
They were.
believe that there's a
Oh, nice.
They brought it out and said, hey, we did.
Good for JC.
they only brought it out once.
And a venue change? Awesome.
What I'm saying is that they brought it out, would it be a conflict in your mind?
If
Is
they-
it a conflict?
Man, that corruption's deep there.
What would be the conflict?
So in a perfect world, what you're
Oh, sublimation? Okay.
is if Ms. Willis had gone to the Board of County Commissioners and said, I am having an affair with this man, but he is brilliant and he would be an amazing prosecutor on this election
So
interference
good.
case.
Well done.
Can I have appropriations of $3 million and I will get it done? And she had said, and I'm going to go on vacations with him and we're going to date and we're actually going to go home to the house
Well
that Fulton
done,
County's
Ashley.
paying for, and he's going to be here for 4 hours at night. If she had said all that and they had given what they gave in Exhibit J,
$780,000.
knowing that, Exhibit J, we wouldn't be here.
Rub his nose in it. Well done. How'd you like that
So
there,
then your
Senator?
client actually has no conflict. Because that would still exist.
That
Your
didn't
client
happen.
has no hard conflict.
That didn't
There's
happen.
no actual conflict. It doesn't matter if you disclose a conflict. If you disclose a conflict, it still exists. And that's exactly what they said in one of the cases that you cited. If a person says, I got a conflict, but I'm still going to testify against you. I know I represented you, and I have a conflict, and I'm going to go testify against you. Conflict is now over. Absolutely not. If you have an actual conflict where your client is harmed, just because they disclose it doesn't end that conflict. So what you're describing is not a conflict at all. You're just saying, I caught somebody, so therefore I'm going to create something and call it a conflict. You can conflict like that. You just could. If your client is...
This guy's just
not
talking
do
in
that for your
circles.
client. If your client is actually suffering harm, as far as how the prosecution is taking place, because that's what a conflict is. Just because she says, oh, I'm doing these things, you're not going to go to your client and say, you actually have actual harm.
Later, Midwest.
She said it, so we would still go forward.
What the heck did he just
Hopefully you
say?
get a run pretty
I'm
soon.
sorry, I don't understand your question.
Yeah, no one has any idea.
You don't have a conflict if you're saying if she disclosed it, it would go away. Then there is no conflict.
No. I did not say that. I said we would not be here if that had happened.
Right,
That's
because
what I
you
said.
wouldn't claim there's a conflict.
No, because we wouldn't be here because it violates so many of the Fulton County statutes.
It would have never
ordinances
happened.
And the state statutes that we wouldn't be here because it wouldn't have been approved.
Right.
But if she disclosed it, not the way you said it.
No.
But if it was disclosed,
hold
it's
on.
disclosed
If
now.
she
What is the
disclosed
conflict?
The undisputed facts, the facts that we all, your side, my side.
How is your
whoever's-
client harmed? Question.
Hold on, I'm trying to answer your first question though. So if all the undisputed facts, if those had been in front of the Board of County Commissioners, we wouldn't be here because there would not have been a contract.
They
Because
would
it's
not
a
have given her
contravention of the law. So we would not be here. I would not be bringing a motion because who knows if my client would have been indicted. Now I wish we could go
Oh, no,
back
you got a
and
much nicer,
and see, but we can't. And so Mr. Wade was
drone than I got.
He should not have been there.
Mine's
He should
like a
not
little
have
toy.
Had the Board of County Commissioners known all of the facts of the case, he would never have been appointed to this case. So we can't now speculate as to what
And
could have happened.
what case law do you point to prove that?
Oh, the statutes. It's
It's not Fulton County statute. I'm asking the Georgia Court of Appeals Reciprocal Court. Is there any case that says that? And it's not.
no, and it's really not surprising, honestly, because can you imagine this happening? I mean,
happens.
honestly, in December, would you have imagined this happening? I think most people wouldn't.
All sorts
A
of conflicts
DA?
are taken up.
I can tell you, I have found some cases in other jurisdictions, but I have never found a case in Georgia where, and mind you, this only happens in Fulton County. So we're talking about Fulton County cases where there would be a special prosecutor appointed, because it's the only place that this happens.
There's no
so
precedent.
Otherwise, maybe the AG. So you're talking about a prosecutor sleeping with the person that she is appointing to do this work, paying exorbitant amount of money, not getting counted, not
Is she
filing.
paying him, or is he earning the money because he's actually billing hours because he's prosecuting the case?
don't.
He's
I wasn't
billing hours
there.
because he's prosecuting a case, correct?
I
A case that a
assume.
grand jury
We
indicted.
don't know. That's the problem.
I
We
would
don't
hope
know.
that he's billing based on work that he's doing. I don't know because I don't
Right.
have proof of that. His billing is very irregular, but I don't know. So I
I
just
mean, words do matter when you say that she's not paying him in that sense.
She gave the
earning-
contract.
He's earning money for a case that he in charge
She
of
approved the
prosecuting
bills.
that a grand jury indicted.
Okay to
and
pay.
That's where we are.
You're
That's-
correct. She is not paying him the Fulton County taxpayers.
As they pay every prosecutor, as they pay every public defender, and every government official that actually exists.
Yeah,
Employees,
100%.
Yeah,
And
and
then
the ones who don't sleep,
process.
they're
And he's prosecuting a case that you're involved in, correct? He's prosecuting, and he's been integral in that prosecution. And you've said that.
He has
I mean,
been
he
integral.
has been very involved. Integral to me means that he is necessary.
Okay, good.
Senator Jones, are you getting close?
Yes, sir. I just had one last question, and that was, in the case that you cited, it clearly says,
Which case? I'm sorry.
in Whitten,
Whitten.
Whitworth versus State, it clearly says, the prosecutor should see no unfair advantage in taking advantage of the accused. That creates the conflict. What unfair advantage has he done in this case?
And you've asked me a lot of questions about Whitworth. I would love a chance to read it. I have a few minutes just so I can actually respond. I don't have it in front of me, and there's a lot of cases out there, and I want to make sure I respond accurately.
Sure, I have it.
Okay, fine.
Yeah, absolutely.
Thank you. I'm sorry. I'm one of those people on visual. I like to see it. Thank you.
This is so lame. This guy is trying to dig into case law. He's not a judge.
While
he
she's
gonna be
looking at
considering
this, we're gonna
statutes or
wrap up
something
here
to
in a
pass?
few minutes. I wanted to let the public know how you can get information to us. Each
Yes.
senator on the committee has a separate email address for committee business, and it's simply the last name of the senator. In my case, it would be Cowser.inv@senate.ga.gov. INV, obviously, for investigation committee.
If anyone
Each
else has
senator,
any,
their last name .inv@senate.ga.gov. David Cook is sitting over here in the corner as the Secretary of the Senate. He is going to be the safekeeper of any documents or evidence that we accumulate. His email address for this purpose will be cook.inv@senate.ga.gov. I've had a number of citizens that have reached out and wanted to provide information or be heard or testify possibly in front of this committee. And we are encouraging anybody that has input or information that might be helpful to us to provide it to a committee member. Ideally to cook.inv@senate.ga.gov, because Secretary Cook will provide it to all committee members.
amazing. Any Georgia whistleblowers out there?
Next meeting scheduled yet, but it will be no more than a couple of weeks away. Ms. Merchant, you may be able to have completed your testimony today, and we may have to call you back for additional questioning after today, but I'm not rushing. Take your time, read that.
Can it not be the first week of April?
Yeah,
Cobb County spring break, please.
that'd be fine.
Thank you. Okay, yeah, no, I'm so glad. So this is Morgan. When you said Morgan, it should have, J-Tom, it should have struck with me. I remember this now. So this case, so J-Tom was actually the district attorney when he first took this case, and he was not.
Don't talk, wait.
Oh, I'm sorry, I forgot that. I'm not good at that, sorry. He took employment later on. So the employment, so it's different than our case because he took employment later on. He wasn't actually paid hourly. He's a member of Prosecuting Attorneys Council. And I'm glad you brought that up because that was one thing that I didn't really go into earlier. The other way that counsel is usually appointed in these cases is the Prosecuting Attorneys Council actually appoints it. Not in that case. But they sometimes will pay an hourly rate if it's something that is needed. But in that case, he was actually the district attorney in another county. And that's what I've experienced before. So The 2 times I've had special counsel, it's been because it's somebody from outside in another jurisdiction that's brought in. So that's what happened in this case. But then he took a job later. The other big difference with that case, and this came up in our oral arguments with the judge, that's a post-conviction case. The standard of review is very different post-trial than it is pre-trial. We're in a pre-trial posture. And we talked about that because the judge asked us a similar question about how to distinguish that. That's the big issue, and the judge pointed that out. That is post-trial. Post-trial, we have harmless error review. It's not a great review. So, it's just like effective assistance to counsel. If you stop the harm before it happens, it's a different review than if you film after it's already done. It's really hard to overturn a conviction once the conviction happens, and that's what you have there.
In this case, they never got to the harmless error because they said that no conflict existed. I understand what you're talking about the harmless error, but they never discussed that because no conflict existed. And you're right, it is post-conviction, but bottom line is, you really did not address the aspects that I was talking about when they say is a conflict, and it's not me putting this case in, talking about a conflict. It was the case that you guys actually did cite. With that, Mr. Chair,
Can I at least answer that question?
Sure.
We definitely cite it because we have, both myself and my husband have a very strong policy of citing everything. We don't hide cases, so if there's something that's adverse to our position, we're going to cite it, we're going to explain it. We don't hide behind it. So we cite adverse authority all the time.
So good.
adverse authority, that's fine.
The oral arguments that we did, that was how the oral arguments started. So
that line of question deals specifically with the legal principles involved in your motion to disqualify. As I understand it, you're not really claiming a conflict of interest between defendants, etc. It's the conduct of the prosecutor.
Yes. Yeah, there's no conflict.
Conduct.
Yeah, we're not talking about the conflict between defense.
We're talking about the fact that the DA's office failed to follow state law and get an approval, failed to follow county policies to get approval of her budget in this contract, that he was which violate county policies.
Yes, county and state. So and we attached that to one of the briefs, her return where she filed it under oath that says, it specifically says if you've got something over $100, you have to disclose it. Oh, here it is. It's so it's called the Fulton County Income and Financial Disclosure Report, and that says, pursuant to Section 2-79 of the Fulton County Code of Ethics, that anytime you've got each gift or favor from a single prohibited source in the aggregate amount of $100 or more. And then it says, purposes of this section, gift and favors means anything of value given by or received from a prohibited source. Prohibited source means any person, business, or entity that the involved officer, so Ms. Willis, knows or should know is seeking official action or is seeking to do or be doing business with the county. So obviously that would apply.
Okay. And failing to respond to your open records request and potentially give us testimony under oath if your version of facts is proven to be true.
Yes.
Okay. Keep us posted. I guess we'll keep reading the press as to how your case progresses, I guess there. I'm troubled about this Find the Votes book. Are you saying that the prosecutor has been discussing an ongoing prosecution and her prosecutorial strategy and indictment
exactly what he's saying
to authors of a book during the course of the prosecution?
Yes.
And
yes.
that book is now come out?
It is. In fact, I don't think I brought it with me. No, I have a copy. We admitted a copy at a hearing. No, it's out there. It was published,
Is that a violation of ethical obligations in some way to be publicly discussing, just like the public statements you made about the guilt of a defendant, etc.?
Yes, definitely, and we allege that and argued that as far as forensic misconduct. It's very surprising, shocking, and I don't know that there's a ton of cases on it, but that book. Also, we talked about it somewhat in our hearing because it goes into a lot of details about the financial troubles that Ms. Willis had prior to becoming DA. And so, it talks about that a lot.
Is she getting a financial benefit from that book?
I don't know.
Is she getting a royalty or payment for having been a contributor to it?
I have no idea.
Okay.
But I know her dad testified that he was interviewed for it. He came to the district attorney's office and was interviewed for it as well. And I think that was when her dad first learned that she had dated Mr. Wade, I think. But I may be wrong. Or maybe that's the first time they met, something like that.
Well, thank you for your willingness to testify before us, and the documents you provided. We'll need some time to analyze and review those, and again, all committee members have access to those. At David Cook's office, he's got them literally locked up in a room. We are not making copies or disseminating those. I will review the documents in more detail, and I'll confer with you, Senator Jones, if you're able to. We might can agree on what should be kept confidential there. I noticed some bank records and things that if it were me being investigated, I probably wouldn't want it divulged to the public. I don't think that's necessary for us to do our job here. I do appreciate everybody's attendance, and thank you all for making time to be here on our committee day. We'll keep you posted further meetings. The meeting is adjourned.
Well done, Ashley Merchant. Oh my goodness, my friends. That was a heck of a hearing. And so they are done. The Georgia Senate wrapping up a pretty incredible hearing. Ashley Merchant did just an outstanding job. And you get the screen and everything resituated, get the dudes reconnected. We're going to do a debrief on everything that just happened. And of course, we're going to jump in and hear from you, get your questions and your comments and all the things that have been going on out there in Fulton County. So absolutely incredible. Let's give a quick debrief on what happened. So of course, Ashley Merchant testified. She's the defense attorney there for Michael Roman, a co-defendant in the Trump RICO case. And she was called here on just one of several investigations that are currently underway. Georgia's Senate is going to be the entity that's responsible for conducting this hearing. And there's a big question about whether they can do anything or not. And we've heard from 11 Alive and other Atlanta news sources that they really can't, they can write new legislation and pass new laws and codify things that might prevent this from happening again. But it's unlikely that they're going to be able to pass a resolution to go after Fannie because they're a whole separate branch of government. But they did expose a lot of this for all of us to see, and we got to hear from Ashley Merchant without objections, without the government, without Fannie's office trying to cover up all of the evidentiary history there. And so Ashley came out, and boy, was she prepared. Oh my goodness. The audio is crackling now? All right, hang on a second. Let me turn that down. How's this now? How's the audio? Audio's crackling? Better? Audio's breaking up bad, choppy audio? Oh man, everything is so wonked out here today. All right, let me turn this mic down a little bit. All right, how's that? I had it overdriven for the show. How's this a little bit better? A little better now? All right. So, carrying on. I turned it way up because the court volume was very loud. So hopefully it's a little bit better.
Very low.
Better now? All right, it's good now. Okay, I had to turn it way up, so my apologies. But, all right, so Ashley came out. Quick summary from her. Calm, poised, extremely prepared. She sent subpoenas all over the place to everybody. She was getting document records from badges, right? Whether Nathan Wade was entering and exiting the building. And the whole thing was incredible, right? She had a lot of work that she had done. And we learned a lot from today's hearing. We learned that Nathan Wade was paid out a bunch of seizure funds. So Fannie went to Fulton County, said, I need a bunch of money. They gave her up to $5 million actually, but he only got paid, or she got that first initial disclosure of funds, which was about $780,000. But Nathan Wade got a bunch of that. And it was for COVID. It was not for election interference or election prosecutions. And of course, that's what Fannie just maneuvered that to do. And so none of that was approved for the purpose for which she used it. We had Dexter Bond just stamping these things with her stamp. And there was a lot of history there about Nathan Wade and Fannie Willis meeting with the White House, meeting with the J6 committee, and the billing records were completely off, right? He was hitting 35 grand every month, and when he could,
hitting his max cap and just saying, I had a meeting with so-and-so and a meeting with so-and-so. And all this stuff was way outside of the norm. And we put together a very nice timeline on the billing stuff. So he billed tens of thousands of dollars even before the indictment started. There was conversation that who was with Fani Willis during her transition, and a bunch of overlap between the campaign, between the DA's office, and between the relationship with Nathan Wade. We also learned that they met off campus with the J6ers, with the J6 committee, and also met with VP Harris, and also billed 24 hours in a day. Of course, we knew all of that, but Adam was able to come out and provide a little additional context and a little bit more color on the whole story. We also learned about Wade's background a bit. He was apparently a solicitor. He only prosecuted misdemeanors. He didn't prosecute felonies. Now he's leading 19 felonies and a huge national case. So, of course, that didn't make a lot of sense.
All right, guys. Another busy day. Probably won't be able to go live again until later if I am, even then. So we'll see. Peace. Have a great day, everybody.